Do it, Your Honor.
We'll give you an extra 15 seconds on the timer here.
Yes, we're feeling generous.
Good morning, Your Honors, opposing counsel, and may it please the court. My name is Josie Holland, and I represent the appellant, Albert White. I'd like to request 4 minutes for rebuttal, please.
Thank you, Ms. Holland. 4 minutes.
This case turns on 2 suppression rulings, and if those are wrong, the convictions cannot stand. First, the warrant in this matter fails to comport with the constitutional requirements as it relates to nexus. 3 controlled buys in a car on a roadway at the defendant's residence without any further facts about observing Mr. White coming to and from the residence or any other facts to support the connection between the interior of the home or the outbuildings cannot support a search of both the residence and the shed. Second, even if the warrant survives in this situation, the only direct evidence that connects Mr. White to the 79 grams in the shed are statements he made while he was handcuffed in his own front yard during the execution of a search warrant. And these are the circumstances regulated by Miranda versus Arizona and Rhode Island versus Ennis. Turning to that first issue, the search warrant lacked a sufficient nexus to justify the residential search. The analysis is confined to the 4 corners of the affidavit and whether the magistrate had a substantial basis to conclude that evidence would be found in the residence and its curtilage. The only connective tissue is the repeated assertion that the CI met Mr. White at his residence, quote, at his residence located at 356 Walton Loop, end quote. There are no facts about where on the parcel the sales occurred, no observations of him entering or exiting the home. There's no explanation within the affidavit of why drugs would be stored in the home or shed. The affidavit fails to connect the interior of the house or the shed to the drug inventory. The warrant suffers from the catch-all general warrant language that would only make sense if there was already a solid nexus to a particular stash. Indeed, Detective Bayless indicated he wasn't sure what he was going to find. The poison of generalization infects not only the things to be seized, but also the places to be seized. The places to be seized are broader than anything that the criminal informant ever saw or anything that the affidavit ever ties to the sales in the roadway. This case looks like night wine because this court says that to simply say at a particular address is insufficient to establish the nexus requirement within the warrant. And without these critical facts, even failing to cite the officer's experience or knowledge that drugs are usually stored in a dealer's home, that's absent from the warrant. The court's order, written order, supplemented after the initial filing of the brief, the court's order underscores just how thin this affidavit is. While it upheld the warrant, it did call it a close call and cautioned law enforcement that in the future it should include even more additional facts about the criminal activity and the place to be searched. Now, any deference must be grounded in facts. When the trial court calls it a close call on the question of nexus, that's an acknowledgement that the police were operating on the outer edges of Article 1, Section 7. If there are no questions about the Fourth Amendment warrant issue, I'll continue on to my second issue. So, turning to the second issue, the Miranda problem. The Miranda problem provides this court with 2 independent routes to suppression. First, if the warrant fails, then the statements are fruits of the same unconstitutional search and fall under Fourth Amendment exclusion principles, excuse me. Second, even if this court upholds the warrant, these statements were obtained during a custodial interrogation of a handcuffed defendant in his parents' yard without Miranda warning. So let's set the scene. The order finds that after the SWAT patrol pulled up, Mr. White was handcuffed and kept in the yard while officers moved his elderly parents from the house. Investigator Williams approached and asked Mr. White how he was doing. Mr. White, concerned about his parents, asked if they would speed things up. And if only so his parents could go back inside. Williams then said, Williams told Mr. White he knew why the police had come. And he went over to his partner, Detective Bayless, and he relayed what Mr. White had said to him. So Detective Bayless, who was the lead investigator in this case, approaches Mr. White, and he says, "Did you tell my partner that you would show us where the drugs are?" And in response, Mr. White told them that they were in the shed, and he began walking towards it. Now, everyone agrees Mr. White is in custody. The only question is whether he was interrogated. Bayless's follow-up interrogation under Rhode Island versus Ennis, as well as State versus Walton, is an interrogation for which Miranda warnings were required, because interrogation includes not just explicit questions, but any words or act officers know or should reasonably know that are reasonably likely to elicit an incriminating response.
So you're saying that the first officer coming up and saying, "You doing all right," or "How you doing," that's not an interrogation, is it?
He's in custody. How are you doing? That doesn't reasonably relate to the crime that they're investigating. So, no, I would not say that that is an interrogating statement.
Okay, so does the record show immediately after that innocuous question that it was the defendant who offered to do something to help the officers out?
I think Your Honor's headed toward the point that this was some sort of voluntary admission, and the appellant would have to disagree with that characterization.
Well, tell me how it's not at that point. We haven't gotten to Bayless coming into the picture.
Well, at that point, when he offers to, can we speed this up so my parents can go back inside the house, we don't have him saying, "Let me take you to the shed." He's merely offering to comply. So,
Yeah, but what could he do to speed things up at that point besides tell them where the drugs are? I'm trying to read it another way, and I didn't know if you could help me.
well, when he makes that offer, so it would have been very simple at that point for Bayless to come over and simply give him his Miranda rights. Say, "You've said this to my partner, you have the right to remain silent, you have the right to an attorney," et cetera, et cetera. But that's not what happens. And the mere offer to speed things up would not be an incriminating statement that would have harmed him at the trial of this matter. We're not to the point where he's actually led them to the 79 grams. But once Detective Bayless comes over, he does not read him his Miranda rights. He says, "Did you tell my partner you would show us where the narcotics are?" And that question is designed to elicit two things from Mr. White. It is both designed to elicit a confirmation that he's going to cooperate with police, and it's also designed to find out where the drugs are. So under Ennis and Walton, he is asking a question which will lead, or is reasonably likely to lead, to an interrogating statement.
But the trial court said on that point that they were merely asking him to restate something that he had already volunteered, absent interrogation. So what do you make of the trial court's conclusion on that point?
We disagree with that characterization, because when Detective Bayless comes back, it was his responsibility to provide the Miranda warning. Just because there was an initial voluntary statement made does not eviscerate the requirement that a defendant be told his rights. A lead investigator asking a handcuffed suspect during a raid, "Did you tell my partner you'd show us where the drugs are?" is not a benign housekeeping question. It is designed to secure those two incriminating statements. And that is exactly the kind of thing that Walton says that Miranda requires. Now, if there are no further questions on the Miranda issue, turning to the question of sufficiency of the evidence. Our argument on the sufficiency of the evidence is derivative. If your honors were to find that the evidence should have been suppressed under the Fourth Amendment, obviously all of the 79 grams would be excluded, and we would not be looking at the crime that says over 26 grams and the handgun, those issues, those would all be out. But I think where we get to the sufficiency problem is if we're looking at the Miranda issue, and the state sort of brings us to the court's attention, isn't that simply harmless error, to which the appellant would say it is not. Because the evidence would have been far weaker for the state if the only evidence was that on a multi-generational home that there was drugs in an outbuilding to which anyone could have had access. The Miranda the statement that should have been suppressed as a result of Miranda, that connects Mr. White's knowledge to the drugs, and that results in an incriminating admission.
On a sufficiency analysis, though, don't we analyze all of the evidence that's in the record, even if it was erroneously admitted?
Your Honor, on the sufficiency analysis, you would analyze all of the evidence both within the suppression and all of the evidence that was given at the suppression hearing and at the trial. So I believe the answer to that question is yes.
We would consider all of the evidence at trial, even if it was erroneously admitted?
Well, I think we're maybe putting the cart before the horse there, Your Honor. If Your Honor were to find that on either suppression issue that the court misapplied the standards, we would revert to the point at which we would have the motion to suppress. But I believe Your Honor's statement is accurate. Looking at the sufficiency of the evidence from retrospectively, we would look at the evidence that is.
Is what?
That we would.
What I'm saying is when we're analyzing sufficiency, we can't cut out the evidence and pretend that it had been suppressed. We analyze the actual evidence that was presented at trial. Am I
Correct,
wrong
Your
about
Honor.
that? Okay.
Yeah. So what we're asking in this case is that you would vacate the convictions and you would reverse the holdings on the motion to suppress, and then we would remand for a hearing that would comport with this honorable court's opinion. That's what we're asking for. Your Honor could not just simply say insufficient evidence because it should have been suppressed. I thought that's the question you're driving at, Judge. If there are no further questions, I'll yield to my friend on the other side. Thank you.
Thank you. General, thank you all for your flexibility as well, even though you already would have been here, I see, but thank you.
I sort of
all
hoped
of you.
that, I saw some emails later in the afternoon that maybe someone dropped out and I'll go from 4 to 3, maybe 2.
No.
I'm flexible.
No,
We'll give you 10 extra seconds.
Kirby May on behalf of the state of Tennessee. Good morning, Mr. Honors. And we'd ask this court to affirm the judgment of the trial court and the verdict of the trial court's verdict. This is a bench trial, Your Honors. Your Honor, the first issue we'll go with the order that the my counsel on the other side addressed in regards to the search warrant. As Your Honors know, we look solely at the search warrant itself in regards to it, not evidence outside the search warrant when determining whether the magistrate or the issuing magistrate had found appropriate finding of probable cause. And in the search warrant, it's very clear that it described the information that the detectives received that the defendant was dealing with selling drugs, and particularly that the defendant was selling drugs from his residence at 356 Walton Loop. Based on that information, the affidavit includes that it had an informant that knew the defendant and had purchased drugs from the defendant in the past. That the informant then contacted the defendant, and that the defendant set up 3 separate drug transactions at his residence at 356 Walton Loop. Again, it repeats each time at his residence at 356 Walton Loop. Those 3 transactions were 3 consecutive days, July 5th, 6th, and 7th, where he sold 1.5 grams, basically 3 grams of crack, or cocaine the second time, and 8 grams of cocaine the third time, 3 consecutive days. And the affidavit also includes that the officers set up a 4th buy to be done on the execution of the search warrant for July 11th from that same residence at 356 Walton Loop. What distinguishes this case from Dajuan, which the defense and my friend on the other side references, is this affidavit very clearly references information beyond what Dajuan referenced. On the second page, which is in the affidavit of the search warrant, references the officer was, I believe that Albert White, who's the defendant here today, is in possession of a large quantity of illegal narcotics and has been known to hide large quantities of narcotics proceeds from narcotics transactions and or other evidence throughout the property in locations not commonly located or accessed by law enforcement officers. And then it goes on and discusses that it has that 4th transaction.
So how does he know that?
That would be information, again, it doesn't go in detail, either through the criminal informant or through the investigation that was referenced through the 3 buys or the information that led to the investigation. It doesn't go into detail, no.
Does that need to be in the warrant, though, for the magistrate to be able to make a determination of the reliability of that information, or is that just a conclusory statement?
It's not a conclusory statement because it's based off information they received, and also the final, and I just want to...
And I think that, I'm sure that's true. Like, I'm the least experienced appellate judge in the entire state right now, but I'm probably the most experienced in reviewing search warrants.
Yeah.
And I would have looked at this and said, I know you know this information because you've set up these buys. You're talking about doing surveillance. The fact that it happened at the residence, is that based upon what your CI told you, or were you surveilling that? Put that in the warrant. So that's what I'm saying is it looks like, you read between the lines, they clearly had more than sufficient evidence, but I'm not sure it's in there. Like, can you kind of explain to me why you can read the wording that's in there and the magistrate who signed this be able to say, oh yeah, based upon these wordings, I know this is reliable information and this is the source that it came from?
Well, yes, very well. I mean, yes. Could an affidavit have more detailed information? The answer is almost always yes. We've done this. They could always,
Yes.
I reviewed search warrants as well. Always say, put a little more, put a little more. But that's not what's required. Is it enough for probable cause, a probable nexus of what the transaction with that, the crime that's been alleged will be found at that address or that location. And the courts permitted, the trial court, the issuing magistrate permitted to make reasonable inferences based upon the information. And it also includes the officer's experience, and as well in the affidavit, and also notes that based on his training experience, he believes that the drugs proceeds will be found there. So is it reasonable for the issuing magistrate to make that inference? And absolutely yes. And so based upon that and all that information, which distinguishes it from Nightwind in regards to that, because there's that additional information that was not included. And also Nightwind's a little different. Nightwind just lists, I forget the actual address, an address that's like 115 Emory. This one has a little bit more information because it says his residence. It includes residence. And also the affidavit and the search warrant itself includes references to the outbuildings and other, his cars and stuff like that. Again, and you will see from the transcript at trial, more of this is developed clearly at the trial. And we'll get to that second in the sufficiency. But that's why the state's position is there was sufficient information for a court to issue the warrant to show the nexus between the crime that's occurred and the evidence that would be found at that residence. And then in regards to the statement, and I get, Judge Wilson, you are concerned about that statement. Well, here it is. The officers do execute the search warrant. Back a little more. When they execute the search warrants, as they're pulling up, the defendant throws 2 baggies of cocaine to the ground. They detain him there, which is where he was going to meet the CI when they pull up. He throws the 2 baggies. They detain him, grab those baggies, and they begin the search. They hand him a copy of the search warrant. This is Investigator Williams. Hand him a copy of the search warrant, and the search is ongoing. While that's going on, they retrieve the defendant's elderly parents, and if I remember right, and my friend on this will correct me if I'm wrong, I think it was hot and in the summer temperature, and the elderly parents were brought out of the house. And while this is ongoing, the defendant, again, Officer Williams is Investigator Williams is standing next to the defendant, and the defendant, I think the quote from Investigator Williams was, and it's in the transcript, it's a little off, but it says, the defendant asks him, if we can get back inside, I'll take you to them. I'll show you where they're at. That's the defendant, that's, I believe, the quote from Investigator Williams that said the defendant said that. In response, as Investigator Williams said, I did not ask him any further questions. I was not the lead detective. I went to Detective Bayless, who was the one, both were involved in the investigation, the buys, and everything else, but Detective Bayless was the lead case officer. Detective Bayless then got that information, walked back to the defendant, and simply asked to confirm, or are you willing to show us where it is? And that's the entire extent of the question that was asked. In response, the defendant told him it's the shed and pointed out the shed. Again, that's not interrogation. Had the detective investigator asked multiple questions, going further, asking additional information beyond, are you willing to show us where the drugs are? That was the only question that was asked. If there had been other questions, then we definitely get into a Miranda issue, asking outside of what he had previously already stated. So the state's position, this is not a Miranda issue. However, even if it wasn't, even if this court found that that second follow-up question, all that information has already been provided. Again, both detectives testified, the search was ongoing, and the search warrant included the shed and outbuildings. The detectives testified, they were going to search the shed anyway. Now, the next step is why we say that if there was error, it was harmless, but simply because they were going to search that shed anyway. And then defense now, my friend on the other side argues, well, then it goes to the constructive possession argument, the finding of constructive possession. Well, you got multiple buys from the same location, for cocaine or crack cocaine on 3 days. This is 4 days later. When they pull up, the defendant throws another almost 6 grams of cocaine to the ground. And then they're searching, once they go in the house, they find in his bedroom, or in the bedroom that's associated with him, his driver's license, a copy of his driver's license, social security card, some records regarding his vehicle that was in the driveway, clothing that appeared to match his style, a safe with, I think it was $8,000 in cash, as well as an assault-style 12-gauge shotgun with extra ammunition and extra clips, and a digital scale. So all that there, then, even if you to ignore the second comment. You can't ignore the first comment because that was completely voluntary, where he makes reference that he possesses other drugs at that location. It's not saying they're specifically where it is, but he's referencing, he knows the officer's looking for additional drugs, and he acknowledges that he possesses drugs in that location. Even if you ignore that second statement, that first statement comes in. And so beyond the evidence looking in the light most favorable for the state, it's overwhelming in regards to that. And we'd ask this court to affirm the judgments of the trial court and the trial court's verdict in this bench trial. Thank you.
Thank you, General. All right, Ms. Holland, I believe you have 4 minutes.
Appellant simply cannot agree with the state that that second question was not an interrogation. If Mr. White wasn't handcuffed, if the raid wasn't ongoing, he is undoubtedly in custody. There's a break from the first officer, and the second, presumably more experienced officer, comes up and he asks a second question. That required a Miranda warning, and it simply is not here, and that's a violation of his Fifth Amendment rights.
What does that get you, Ms. Holland, though, to answer the General's argument? They had a search warrant for the shed. They were going to search it anyway. So we're really talking about his statements providing his guilty knowledge of the drugs. Well, they have him doing controlled buys there. They found the drugs in his bedroom. Is it really harmful to your client, even if those statements did come in?
Yes, Your Honor. It is harmful to the client if those statements come in, and they should have been suppressed. It would have provided, because it demonstrates his knowledge of it, and certainly I'm not even sure that the officers themselves expected to find 79 grams of narcotics in the shed. And that's part of the problem is this was, and from the blanket language in the warrant, this was a bit of a fishing expedition for them.
Well, how do you get around the fact, though, that he threw bags of cocaine in the ditch when they pulled up? There were drugs in his room. Were there not?
Paraphernalia.
Paraphernalia, I apologize, paraphernalia. I mean, doesn't all of that speak to his guilty knowledge, absent any statements that he made at the scene?
Well, if we're looking at the warrant question, Your Honor, no, none of that bears on his guilty knowledge, because we're confined to the four corners of that affidavit. And I'd like to talk in my remaining
Yeah,
time.
but I'm talking about the Miranda issue. Like the affidavit, the warrant's been issued, they're serving it. So when we're talking about Miranda, that has no bearing on whether the warrant's valid.
I understand, Your Honor, and I suppose, you know, he's got the 6.52 grams that he throws in the ditch. For certain, he would be convicted on those. But there is a question if the statement that he makes about, I'll show you the rest of it, if that would have led to a conviction on the other 79 grams, and of course that matters because of whether or not it's over 26 grams. But I understand what Your Honor's saying, that there is some other circumstantial evidence, but his Miranda, the statement that should have been suppressed under Miranda was his only direct connection to that 79 grams. But in my last 50 seconds, I want to talk about where that criminal informant was. That criminal informant was on a roadway adjacent to the property. And so the criminal informant's basis of knowledge is only what is in that car and what is on that roadway. They're under McLawhorn and Hogan and Nightwine. This is not the protracted pattern we see in Sane. These are 3 controlled buys over 3 consecutive days, and they're executing the warrant, I believe, on the 11th of July. And so our criminal informant's basis of knowledge is very limited, and it is limited to that roadway and those cars. There's no other information connecting the evidence to the interior of the home. We would ask Your Honors to vacate these convictions, to reverse the holdings and the motion to suppress, and to remand this matter back to the trial court for hearings consistent with this honorable court's opinion. Thank you so much.
Thank you. Thank you, counsel. That's our last case of the morning, so we will stand in lunch recess until 1:30.